Welcome to Divorced from Reality with Johnny Bardine.
Welcome to Divorce from Reality with Johnny Bardine. Johnny is a dedicated attorney who has been serving the Tampa Bay community for over a decade with the mission to help individuals and families through their most challenging times. Johnny provides compassionate, fierce advocacy in divorce, foreclosure, personal injury, and probate matters. I'm Evan Mack, and today we're talking about what happens when a parent needs to move or relocate with their children after divorce in Florida, and how the law balances opportunity and stability for families. Johnny, sir, welcome back.
It's good to be with you again, Evan.
Awesome. So we're going to talk about relocating with children after divorce in the state of Florida. When a parent wants to move after a divorce, for example, they got a new job, closer to family, whatever the reasons may be. When does that become a legal relocation in Florida, and why does that distinction matter?
That's a really great question, and one that we get a lot around here. And the rule is that under Florida law, move becomes a legal relocation when a parent wants to move further than 50 miles or
50.
more from their current residence for 60 days or longer.
Okay.
And that move would affect the child's residence. The 50-mile rule is important because if it's less than that, it's not considered a legal relocation under the statute, and the parent can move within 50 miles. But once you hit that threshold, the law kicks in, and you can't just move. You need permission from either the other parent or the court.
What are some common reasons parents to decide to need or to move, and how do courts determine whether the move serves the child's best interest? I mentioned jobs and things like that, but are there other factors or other things that you've seen for a significant reason?
Well, that's the reasons are the ones that you might expect. New job opportunities, better pay, lower cost of living, being closer to extended family for social and familial support, or sometimes to leave a toxic environment. The courts
Right.
understand that life moves on, but the primary focus is on the best interest of the child, not just what's best for the parent or more convenient for them. And so in that vein, Florida courts look at a lot of factors that they need to determine whether relocation is a good move, and the quality of the schools in the new area, the child's relationship with both parents, uh, the children's age and development needs, whether the move improves the child's quality of life, things like that. So the driving force always, and we'll talk about the specific statute in a moment, but the driving force is always going to be what's in the best interest of the child.
If both parents agree on the move, what's the formal process for this documentation that or the agreement so it's enforceable?
Right. So relocation litigation can be difficult, and there's a time sensitivity there that sometimes uh, is difficult to achieve because the court process is so long. So if you're looking to move for a new job, it might be a difficult thing to do quickly. So if both parents can agree and they're on the same page, that's really good. And so the Florida statute has that built in. So the parents can sign a written agreement that states that they both consent to the move, they agreed on a new time sharing schedule, and they've worked out any transportation arrangements. That needs to be filed with the court. And if there's no objection from the judge, again, they need to ratify that the agreement's in the best interest. It can be approved without a hearing, generally. But if it's not filed, if it's just verbal, then it's unenforceable. And that can sometimes create problems down the line. So relocation can be a difficult process, but if the other party consents, that's better. And I've had some divorced parents agree to relocate to the same place, which is it has been rare, but good for the children.
Yeah, it was a little bit different for me. It was Pennsylvania as opposed to Florida when my parents got divorced. My mother was still like in the service, so she went to like Germany. You know what I mean? But
Yeah,
my parents were always kind of amicable about that kind of stuff, though. So like I kind of went, but it was still an interesting situation. I remember as a kid.
yeah, it sounds like your parents did a good job of not losing sight of how difficult that could be, and they chose amicability over litigation, which is always the preference.
Right, right. So, but when parents don't agree, what steps does the relocating parent have to take before they can legally move with their child in the state of Florida?
Right. So if there's no agreement, the Florida law requires that the relocating parent file a petition to relocate with a minor child. The operative statute there is 61.13001, and it's a bit technical in that you have to know at the time you file the petition the exact location of the intended new residence,
Mm.
the reason for the relocation, and you also have to file a proposed time sharing schedule and account for the transportation plan so that the non-relocating parent can still engage and exercise meaningful parenting time. Once it's filed, the other parent has 20 days to file an objection. If they do, the court schedules a hearing and the judge decides whether the move should be allowed. Um, you cannot, this is very important, you cannot legally relocate the child during this process unless the other party agrees to it. So don't try to jump the gun. You need to wait, if the parents don't agree, for the court to make a decision. Because if you do, if you move or if you relocate prematurely, you're going to be penalized for that, and that really relocation petition is likely going to get denied.
Wow. Well, what kind of evidence or details make a relocation request stronger? Things like new job offers, schools, support systems, anything like that kind of buffer the relocation?
Yeah, yes, yes, and it's important to know that the judge wants very specific details and not vague promises. And in some of these cases that I've had, I've felt a little bit like a member of the Chamber of Commerce for the other place because I've provided information about the other party's schools or sports leagues or extracurricular activities. I've presented maps that show the proximity of extended family members to to
Mhm.
where the children will live if the relocation
Wow.
granted. So, but specifically, if the reason is a new job, if that's one of the reasons for the relocation is a new job, you should have a formal job offer letter,
Yep.
uh, as specifically as possible with details about pay,
Yep.
benefits, career growth. You need the information about the schools in the area, especially the specific one that you're going to tell the judge the child is going to go to.
Hmm.
And then, as we said previously, proof of the family support and a detailed parenting plan. There's a lot of documents that I think would be helpful in relocation, but those are the primary ones.
How do Florida courts weigh the potential benefits of relocation against the impact the other parents' time on the times parents' time sharing rights?
It's quite literally a balancing act. The judge is going to weigh the benefits of the move for the child and the relocating parent against the potential harm of the child's relationship with the non-relocating parent. So we mentioned the statute, and I'm trying not to be so dense about it, but there are 10 factors that the court is going to look at when determining whether relocation is in the best interests. And neither of those, there's no presumption that any of the factors are more important than the other ones. So
Mm.
it's quite subjective, and it's tedious because you got to check on those as many of those boxes as you can. One of the things that I think is sort of psychologically interesting about this case is that you need to convince a judge who lives in your community where your client lives and has gone to and has sent their kids to the same kind of schools and things like that, that there's some other place that's going to be better than the place that they're at now.
When when it happens, what happens if a parent moves without this process though, or there are there consequences? You talked about the relocation perhaps being rejected, but can things be corrected after the fact? What are some of the things that could happen if a parent doesn't follow the proper protocol?
I strongly, as we said before, I strongly advise against doing that because that can seriously backfire. If a parent relocates a child without following the law, the court can order the child to be returned immediately. They
Mm,
can hold the parent in contempt because they violated the existing court order,
mm,
and it may be a basis to reconsider the time sharing entirely, and sort of engender the opposite effect of what the relocating parent wanted.
Relocation can bring a lot of stress for the kids and co-parents alike. How do you help families handle those emotional challenges while keeping the communication productive and understanding that this has to happen?
One of the things that we do in my practice that I'm proud of is that we really think about this in a holistic and comprehensive way. And these cases, even if are fairly amicable, have a lot of emotional toll and mental health
Hmm.
effects on people when they're doing it. So, and this relocation is one of the most emotional areas of family law. And so I always remind my clients that the legal side is just part of it. And the emotional impact on the kids, the sense of loss for the non-moving parent is real. So I recommend that we encourage early and respectful communication between the parents, that we, if we need it, bring in some outside third-party experts like co-parenting, like parenting coordinators or family therapists, and that we build a parenting plan that's going to really protect the non-relocating parent. That would include some uh, travel reimbursements or significant virtual time for FaceTime calls and things like that when they're not with their children. And most importantly, we have to help parents keep the focus on the child's needs, not just their own preferences or convenience or individual reasons.
For anyone listening who's thinking about relocating or facing a request from the other parent, what's the best first step they should make before taking action, Johnny?
The smartest thing you can do at first is don't just move without permission from the other parent or the court, and certainly don't agree to anything in writing without understanding your rights in the legal process. So you have to review the current court order to make sure exactly what your rights, duties, and obligations are already, and specifically with the view to whether there's any abrogation of the relocation terms already that might help you. And then you have to start gathering your facts. What's changed, why you want to move, how it affects your child, and what it's going to be like in the new place. And so I recommend, even if you're not quite ready to retain, that you talk to a lawyer. You know, I'll talk to you for free the first time to talk to you about your rights, your existing rights, and sort of strategize what you need to do to move forward to get the result that you want.
Awesome. Johnny, thank you for the time, sir.
Thanks, man. Have a good day.
And thank you all for listening to today's episode of Divorce from Reality with Johnny Bardine. For more information or to connect with Johnny personally, visit BardineLawFirm.com. Don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode. Thank you so much, and we'll see you
Thanks
next
so
time.
much. Appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.